Brent Mittelstadt speaking, who's a research fellow at the Oxford Internet Institute at the University of Oxford. Who's going to be speaking on the ethical principles and guarantees around AI. Unfortunately, Brett's come down with a little bit of an illness, so he won't be speaking today. But we do have next Peter Rudd and Emma Kislingbury, and they're going to be doing a duet. And they're going to be speaking on AI in healthcare, the legal and regulatory landscape. Welcome on stage.
Good morning, everybody. I'm Peter Clarke. This is my colleague, Emma Kislingbury from the law firm RPC. We'll be taking you through some of the legal and regulatory risks in this sector. You've heard a lot of optimism this morning, a lot of excitement about the possibilities of AI. So with apologies, we're going to bring that down a peg or two. Being lawyers, we're going to give you a bit of doom and gloom, explain how things can go wrong, burst the bubble a little bit. But by the end of our session, hopefully you'll appreciate some of the legal risks and understand a bit more about how to take measures to hopefully prevent them. So, things we've noticed as lawyers in our practice when it comes to AI in healthcare, where some of the risk lurks, we've put on this screen. We've already heard this morning about how AI is becoming more integrated with the diagnostic process. So doctors either ceding some control to AI tools to help diagnose conditions, or else working in cooperation with them, leading ultimately to decision-making about patients' treatment and what kind of interventions they should get. From a legal perspective, as we'll see, that's very interesting. Traditionally, if something goes wrong, a patient would have sued the provider of the care, the hospital, the doctor, possibly the manufacturer. But the courts will now have to grapple with some challenges as we get to grips with what AI can do and the level of responsibility that should be allocated to AI decision-making. Something else which worries us that you've heard about this morning already, and that's the increasing tendency of the public to have access to very complicated health data, information about their own healthcare, and the ability to start making decisions for themselves. And we'll talk you through that too. Training. AI clearly has a lot of potential when it comes to training the current generation of doctors, but also the next generation as well. And as we heard from the Q&A just now, could there be a problem on the horizon if the understanding of senior doctors is going to be swapped out for junior doctors who perhaps have had a different type of training, more reliant upon AI, and perhaps losing some of those skills their senior colleagues have. And finally, we'll give you a couple of scenarios where research is benefiting from AI, but also causing a liability risk in itself. So, here are some of the risk factors we've identified. The first one is, despite a lot of debate about the potential of AI, robots taking over, AI making decisions, there will still be human decision-making at many stages of the AI process, whether that's to design the AI in the first place, choose the input data that goes into the AI before it's rolled out, decisions over marketing and use in the clinical setting. It will still be human decision-making in that supply chain that will prove critical. And unless the law massively develops in a different direction over the next few years, if there is litigation, the courts will be looking at those human decision makers to allocate any liability. But as Emma will talk you through, there are an increasing amount of initiatives to put in frameworks so that the risk of human decision making can either be reduced or properly allocated. Another risk is to do with accountability. So the legal system relies upon being able to determine who is at fault or should be liable in any given situation where something to go wrong. This will become increasingly difficult to work out as we use more and more AI. There's this phenomenon of automation bias. That's possibly going to be a big factor. We've seen that all in our personal lives. Probably most of us have had an experience of automation bias. You might get into your car, put the sat-nav on. The sat-nav gives you a recommendation for a route. You look at it, based on your experience and common sense, you think maybe that's not the best route, but you follow the sat-nav anyway and have a suboptimal journey because of it. Not very, a bit of annoyance in your personal life, but if you have automation bias in a clinical setting where a clinician will disregard their own experience and common sense in favor of a machine recommendation, then you can see that that raises the risk of patients having substandard outcomes. There's also this element of magic. Clinicians highly trained in what they do, lots of experience in their practice areas, but generally speaking, doctors are not computer experts, so they will not fully understand the supply chain leading up to the point where they're using the AI. They perhaps are not involved in the computer programming or the decision making or the data gathering before you get to the point where they, the doctor, have to make use of this AI. A big driver from a government's perspective or a regulator's perspective for the use of AI is saving on costs. So governments like AI, particularly in healthcare, which is expensive because you can do more and more quickly and reduce the expense of human doctors. Fine, except when it comes to trying to apply a legal standard to that, what happens if human interaction from a doctor becomes increasingly the preserve of private patients? So patients, for example, in the NHS may have less interaction with doctors, but those perhaps in the private sector who can afford it might still retain that interaction with the doctor. The question then arises, will we have two standards of healthcare? One standard where, for most people, there's less human decision-making, but for other people, the minority, there's still that traditional interaction with the doctor. And then from the law's perspective, trying to work out what's the appropriate standard of care across the board could prove very difficult. Next up, we've got the well-documented limits of AI. So data may be collected, which could be prone, as we heard in the Q&A session, to bias. We increasingly understand that a lot of historical data has been skewed towards data gathering from white, male, Western people to the detriment of other demographics, and that can lead to poor outcomes. There has been some recording of a worrying phenomenon of hidden preferences. This is where data or AI is supplied by one particular company, loaded, perhaps accidentally, with a preference to recommend prescriptions or treatments or medical interventions or drugs from a company that has a connection with that other company providing the AI. So unbeknownst to the doctor, the patient is being funneled towards a treatment which has a commercial value, which could reduce the appropriate level of treatment for that particular patient. We've already heard about medical records this morning. For a lot of practitioners, they can be problematic. For lawyers, they can be extremely difficult. If you're faced with a piece of litigation, one of the first things you will do as a defense lawyer in particular is ask for the medical records, and experience tells you that medical records are often partly digitized, partly handwritten, they may be incomplete, they may be in the wrong order, but AI depends upon medical records being digitized and machine readable. And from a lawyer's perspective, you can see that if you were to feed in standard medical notes into an AI algorithm and ask it to work on it, you can see the AI may be missing crucial data, and that will lead through to a poor outcome. We've put Ebola on the slide here. We were asked to submit our slides 2 or 3 weeks ago. I think if we were submitting them more recently, we would have mentioned the coronavirus. Why is that? Both Ebola and corona are examples of where, even in the modern era, you can have very fast-moving situations involving diseases which are new and poorly understood. Under those circumstances, we've seen both with Ebola and the coronavirus, it can be very tempting to reach for an AI solution, whether that's trying to manage the treatment of populations at a big level, or whether it's to use AI techniques to speed up clinical trials and try to produce a vaccine. Great, there's the potential for AI there, but if you have a poorly understood disease and a lot of media pressure, government pressure, to try to find a solution quickly, then just by virtue of the fact you're moving at speed, you can create risk which would otherwise not be seen. As lawyers working for manufacturers, we worry about the public. Increasingly, they have access to smartphones, smartwatches, other data, research on the internet, and armed with this data, people can start to make decisions, particularly if they're concerned about access to seeing a GP. Would you wait a couple of weeks, or would you start acting on the stuff coming out of your phone or your watch and try and take some steps? Some people would. And there are two types of people we particularly are concerned about. One is the worried well, people perhaps for whom there's nothing actually wrong with them, but they have a tendency to look at data on a daily basis and really get into it that's being spewed out of their device and act accordingly, bypassing a doctor, self-medicating, possibly taking drugs illegally over the internet without any kind of medical professional intervention, therefore creating a lot of risk for the manufacturer of that device. The other people we worried about are the unworried unwell. So these may be people who have a self-image of themselves as being extremely healthy. They look at the data, they see what they expect to see reflected back at them, and they don't go and seek medical intervention when they should do. Again, that kind of person creating risk for any manufacturer or supplier of AI. And if we had all day, we'd go into some other stuff as well. Your legal advisors, your legal teams may also be grappling with these issues to do with data protection, IP protection or IP violations, and a whole host of regulatory challenges too. So we've had to think about what AI litigation might look like. I think we've established this morning that AI in healthcare is pretty nascent in its development. There's a long way to go. Unfortunately, the lawyer's message is with any new technology, it's only a matter of time until there is some litigation, in part so the legal system can thrash out some new principles and everyone can work out how to adapt to a new era. So far, litigation involving AI has been pretty piecemeal, pretty small in scale. We've dealt with some of it. It has been not really particularly in the headlines, nothing really reported so far for us to really explain to you today. But based on experience in other matters and other technologies, we can give you a steer on what could happen. Crucially with AI, if there's a defect in it, then you're probably talking about hundreds, well, maybe thousands of patients being affected at any one time. If there's a glitch in software leading to the same problem or mistake being replicated in many people, then your hundreds or thousands of patients could unfortunately become hundreds or thousands of claimants in a legal scenario. People we work for, the manufacturers, are very keen to roll out their new technologies in multiple jurisdictions as quickly as possible. If they develop something, say, in the UK, they want to then get it regulated under not just the EU framework, but also the States framework as well, and sell it around the world. So if there is a problem with your AI, and it only becomes apparent a few months or years down the line, you could be faced with a situation which is truly international in its scale. Based on experience, the courts are likely to deal with any litigation using group actions, as we call them in the UK, or class actions, as they're known elsewhere, essentially to take hundreds or thousands of cases together, bring them all together, look for common themes, and try and work out a way of resolving the litigation involving test cases so that the judgment can be applied to all the claimants who are in that particular class. So that means from a manufacturer's or a hospital's point of view, litigation would be relatively streamlined, but carry with it the risk that one court case could prove absolutely fundamental to the future of a particular company or a technique or a product. And in dealing with litigation, because it's international, you'll probably be looking to try and resolve it on a global level before some problems crop up, basically because the defect could be the same in many places around the world, but legal systems differ, procedures differ, timetables differ, and what you don't want is the risk of a bit of satellite litigation in a jurisdiction somewhere polluting what's going on in the rest of the world with your defense. Although there hasn't been much AI litigation, the legal world has got experience of quite significant medical devices or medical products litigation from the last few years. So we're talking about PIP breast implant litigation, metal and metal hip litigation, other pharmaceutical litigation. So there are templates out there so that if there is AI litigation, I think these features would probably feature pretty prominently. What would happen? Well, from claimants' perspective, if AI goes wrong, they have a few avenues. Traditionally, claimants would look to sue manufacturers or doctors in negligence, essentially trying to demonstrate that the standard of care was lacking, was not the kind of standard of care that would reasonably be expected by your standard doctor or manufacturer or hospital. In some cases, if it's private healthcare, there may be a contractual element to it, and any regulations that are brought onto stream involving AI, if they are breached, then you can be assured claimants would rely upon that too. But talking of AI, because it's a product, it's a service, the route most likely to be taken by claimants in the event of litigation involves the Consumer Protection Act. A little bit of history for you. In the 80s, it was recognized that consumers, whether that's consumers of stuff you buy on the high street or patients who are being given highly sophisticated medical devices, had a very difficult time to prove a product was defective and obtain compensation. The reason being is they had to sue in negligence and therefore prove some kind of fault on the part of the manufacturer. So the European Union, or the EC at the time, brought in the Product Liability Directive. In UK law, that's the Consumer Protection Act. And the key point of this act is that it's a strict liability regime, so that all a claimant has to do is demonstrate that a product is defective and that it caused their injuries, and they will receive compensation. Sounds relatively simple, but is actually rather complicated. The reason being is that the act is pretty wide. It has to cater for, at one end of the spectrum, children's toys, and the other end of the spectrum, highly regulated medical devices. And the two key parts of the act are here. The test the court has to ask is that, is the product meeting the safety standard people are generally entitled to expect? And to answer that question, they will look at what they call all the circumstances. Starting with all the circumstances, Emma will talk about these in more detail, but broadly speaking, this is the stuff that you as the provider can control. You can write your manuals very carefully, providing proper guidance to the user. You can talk to your legal team to make sure the right disclaimers and warnings are in there. You can carry out research properly before the product's placed in the market, and you can keep a lid on your marketing team to make sure that the end users are properly trained. So these are things you can control. What you can't really control is how the court will answer this question about what are people generally entitled to expect. And in a fast-moving area like AI in healthcare, you can see quickly that trying to work out what patients should be entitled to expect from new technology probably changes every day. So there will be a lot of difficulties in grappling with this test in the event of litigation. However, a little bit of good news for you. There is some judicial guidance which I think would feature prominently. And that's this case here, handed down a couple of years ago. This is litigation we were involved in. It concerned metal hips. The background to this is that hip implants, as you all know, have been available to be used by patients for around 40 or 50 years. I'm ready to be corrected if my timescale is wrong on that. But they've been around a long time. There's a fair amount of data showing how they should perform. In the early noughties, a new type of product was brought out, the metal hip. And over time, it appeared that the metal hip was not doing as well for some patients as traditional hips. So claimants brought litigation against around about a dozen manufacturers, saying, look, the data shows these new hips are not performing as well. And based on that data, we can prove that these products are defective. It went to trial, a long 14-week trial, but ultimately the court found in favour of the manufacturer, found in favour of the defendant. So for defence lawyers, this has proved to be a really useful judgment because it's the first judgment really in terms of product liability in a medical setting we've had for about 20 years, and certainly the most up-to-date judgment we've got. It's around about 160 pages long, well worth a read. If you don't want to do that, I've condensed it to one slide for you. These are some of the key principles coming out of that judgment. Possibly the key one for this morning's purpose is the court's recognition that innovation is built into the system and has to be accepted. So when it comes to asking that question, what are people entitled to expect? You have to bear in mind that people, whether they're consumers or patients, want ever more innovative products. Science can deliver more innovation, and regulators are grappling with it as well. So there are passages in this judgment that you can quote back to any claimant where you've got an innovative product, and I think you would put AI in this category, saying, here's a judgment recognizing that if you're looking at the risks and benefits and what the public should expect, then there has to be a degree of understanding that innovation is acceptable. And if there's innovation, there will always be some people for whom the outcome is not what they expected. Perhaps the next key point of the judgment is to do with regulation. Metal hips are Class 3 medical products, some of the most highly regulated in the world. And the court essentially stated the whole point of regulations is they're designed to make the public safe. So if a product is compliant with those regulations, then by definition, that goes a long way to proving that a product is safe and not defective. So as regulations catch up with AI, and you are a provider of AI, provided you can demonstrate you are fully compliant with regulations, you'll be able to refer to this principle here to argue that your product is safe and not defective. And finally, to pick out another point, the claimants in this case relied upon data. They felt they had a lot of data at their disposal, demonstrating that metal hips had not performed as well as traditional hips. And I think if there's going to be litigation over AI, it will be awash with data. Part of how AI works is it's all to do with data collection, data analysis, data output, machine learning based on new data. So if there is litigation, I think data will be closely looked at to see how it performs. But in this case, the court said, well, your data is not good enough. We can see the point you're trying to make. Perhaps you might have won, but actually the data is not robust. There are too many flaws in how it was collected. So on this occasion, the claimants didn't win. But I suspect that if there is going to be significant AI litigation and data is involved in that, then claimants will be going back to this judgment to learn the lessons of what happened last time to try and get it right next time. To bring it all together, whilst we've not had huge amounts of AI litigation, we have dealt with some at our firm RPC. Here's a case study for you. Our client provided software for use in a clinical setting. So readings were taken from patients, and then in the theatre, the doctor had access to the software to provide a treatment. So the doctor would look at the software and based on that software, select an implant for a patient. In this case, there was a glitch in the software. There was an attempt to work around the problem, but that didn't work. So ultimately, the patient was implanted with the wrong product, obviously sued the hospital settled, and the hospital then sued our client, the software provider. So we had to settle the litigation because it was pretty clear that we had a duty of care towards the patient and the hospital, and that the patient had a very strong case under the Consumer Protection Act. A couple of key features coming out of this to take away. I think if our contracts had been better, if our contracts had spelt out more clearly who ought to share the risk in these settings, we might have had more of a defense. They weren't drafted by us. In that case, the doctor, we argued, should have used their common sense to realize the reading being provided by the machine was way out, but the doctor failed to do so. And if that kind of understanding is built more into your contracts and you might have more of a defense. But ultimately, we had to settle, and in a highly regulated area, obviously an investigation had to be carried out, reported to the MHRA, so all the information was on the table, and what you ended up with was an unfortunate situation both for the patient but also the parties involved, involving legal costs and time management costs as well. So a bit of a lesson for you there and what to avoid.
So I'm afraid to say that, as with the claims position, regulation around the use of AI is similarly complex. And I know that we've heard a bit this morning from Jackie in terms of what's going on a sort of global stage in terms of discussion around regulation. And it's not surprising, given the way that AI is touching upon so many different parts of our lives now. So on the screen are just some examples that are specific to the healthcare sector. So I'm just going to give a sort of brief run through of some of the discussion that's going on sort of in the UK in terms of regulation, on the European stage, and globally as well. So in the UK, software is regulated by the MHRA, so the Medicines and Healthcare Products Regulatory Agency, depending on what its intended use is. And that includes standalone software, as well as software that's included in an existing medical device. From a legislative perspective, a House of Lords report in 2018 commented that there's a general lack of consensus around the adequacy of current legislation. If AI goes wrong, if it underperforms, or if it makes an error in decision-making. But despite that, the committee at the time didn't make any specific recommendations. Late last year, the NHSX issued a report that's titled Artificial Intelligence, How to Get It Right. And that report sets out 10 principles in the form of a code of conduct to enable the development and adoption of safe, ethical, and effective data-driven health and care technologies. And the intention is that that code of conduct will work alongside health research, medical device regulation, and other regulatory approvals. And it will apply throughout the whole supply chain. So from those developing and deploying data-driven technologies all the way down to the end user. At a European level, the European Commission has set up an expert group which is reviewing the existing Product Liability Directive, thinking about the wider context of sort of current and new technologies as they're developing. And its Medical Device Coordination Group has issued guidance that came out in October last year. And the aim is to assist developers of medical software to determine whether their products are medical devices. And the key message that comes out of that is whether the developer intends the device to have a medical purpose. Thinking more widely, in the US, in April last year, the FDA released a discussion paper which set out proposals for regulating AI and machine learning-based software. And they put forward a total product lifecycle regulatory approach, and at the moment they're gathering feedback from stakeholders on that. And in terms of where we're going with regulation, well, as we've heard about this morning, AI is a constantly evolving thing, so any regulation needs to be nimble, it needs to be flexible to keep up with the developments that we're seeing. And the question is, how can that be achieved? Well, early last year, the BSI, a national standards body, put together a position paper, and that had input from others, so from the MHRA and from experts within the FDA. And I'll sort of refer to that as the BSI report. And if I just give you a moment to have a look at one of the sort of key messages that came out of that report, what we can see is that the BSI is focusing on the need for there to be a global approach to the regulation of AI, which it emphasises is imperative to ensure its successful use in the future. And how the BSI does this is by looking at the role of standards in supporting the use of new AI solutions. The idea being that those standards can be developed and support existing regulatory regimes whilst keeping pace with technological advances. So regulation is clearly a big issue when it comes to AI, and it's a hot topic under discussion. Only last month, the White House proposed a new set of principles for governing the development of AI solutions in the US, and their aim is to promote public engagement, to limit regulatory overreach, and to promote the development of fair and unbiased algorithms. And the US's chief technology officer acknowledged the need for there to be flexible frameworks that allow for rapid change rather than a one-size-fits-all approach. So, as well as some of the collaborative efforts that I've already mentioned, on the global scale, in June last year, G20 ministers met, and mostly, except for China and Russia, they agreed on some guiding principles for a human-centered approach to the use of AI. And in a similar vein, the House of Lords report recommended implementation of an ethical framework as opposed to a legal one. So we may well see that underpinning any future regulation. So, to try and put some of this into context and to illustrate why regulation is so important, I'm going to talk through a possible real-life scenario. This scenario involves the use of a robot during surgery, but similar issues will also apply with AI-driven technologies. And this scenario, whilst it's a completely fictional scenario, it may be familiar to some of you because it's loosely based on a case which was heard in Newcastle Coroner's Court in November 2018. So we have patient A. Patient A suffers with symptoms of angina. He is examined, he's admitted to hospital, and it's intended that he will undergo coronary angioplasty. Now, as one of the most common types of procedures, of heart procedures, it generally carries a small risk of any serious complications. The hospital where the procedure is going to be carried out has recently acquired a surgical robot to assist in certain types of heart surgery, and it's planned that the consultant surgeon will lead the surgery using the robot for specific elements of the procedure, and a junior doctor will be present to assist. So the procedure starts well, it's all going smoothly without any complications. Consultant is called away to an emergency elsewhere. Junior doctor assures him she can complete the procedure by herself, so the consultant leaves the theatre. After he's left, an issue arises whilst the stent's being inserted, and unfortunately patient A starts to bleed excessively. He suffers some serious complications following his surgery. So just turning back to what Pete was explaining earlier regarding potential defendants in litigation, this is a good example where if a claim were to follow, if an inquest were to follow, there could be many different parties involved. So in this situation, we have the hospital where the procedure was carried out, the consultant who led and who should have been overseeing the procedure, and in some cases there might also be other clinicians or sort of expert advisors there to assist, the junior doctor, the designer, manufacturer, producer of the surgical robot, and potentially the owner of any training data. And we'd also, in this situation, need to consider the makeup of the robot. So Pete talked earlier about the risk of product liability claims under the Consumer Protection Act. And this raises the question here of what is the product in this case. So the surgical robot is likely to be a product and therefore a medical device for the purpose of any regulation. But what about the underlying software? Is that also a distinct and separate medical device? And so a scenario like this raises a number of immediate questions. So firstly, what actually went wrong that led to the excessive bleeding? Was it a fault with the robot? Or was it nothing to do with that, and would it have happened even if a more conventional type of surgery was carried out? What experience and training did the consultant and or the junior doctor have in this type of surgery? What policies and procedures did the hospital have in place regarding the use of the surgical robot? Were these adhered to? And I would think probably not, given that the consultant left partway through the procedure. How much evidence was there regarding the comparative risk of robotic-assisted surgery as opposed to more conventional surgery? Now, the coroner in the Newcastle case specifically warned of the risks of there being further deaths from robotic heart surgery. She concluded in that case that the patient who had undergone surgery to repair a leaking heart valve had died in part because the operation was undertaken with robotic assistance. In that case, it was found that 2 proctors, so expert doctors who were present to advise on the use of the robot in that surgery, should have been present throughout the operation to provide advice during new procedures. Both left partway through, meaning that they weren't in a place to assist when problems arose. It was also found that there was an absence of any benchmark for training on new interventional treatments at the hospital. In her summing up, the coroner confirmed that she would be contacting the Royal College of Surgeons as well as the Department of Health to ask them to consider whether national guidelines needed to be brought in. So, whilst there are many potential benefits to the use of robotics in surgical procedures, such as better, faster, and potentially safer clinical care, there are clearly a number of risks that also need to be considered and potential issues that need to be addressed. And accountability is clearly a serious and complex issue with both robotics and with AI, particularly so in areas like healthcare where patient safety is so critical. So a regulatory structure that's clear, consistent, and current, and flexible to meet the demands of a constantly evolving sector is vital. And the BSI report suggests that regulation and standards for AI technology should remain distinct from those that address professional practice and healthcare service operations. So their view is that it's really important that clinicians effectively remain accountable for the decisions that they make. Now, interestingly, in contrast, there's been a suggestion at European level of considering granting legal status to AI-based robots. So thinking about this idea in a bit more detail, I'm just going to ask for a very small bit of audience participation with a quick odd one out round. So I'm going to give you 3 examples of situations where the legal status of non-humans has been an issue in other fields. In 2 of the 3 examples, legal status was granted, and in 1 example, it wasn't. So for each example I give you, I just want to ask you to raise your hands if you think that in that case, legal status was not given. So can I just ask you, put up your hands if you think that legal status was not given in the case of Sophia the robot. And if you think that it wasn't given in the case of the Ganges in India. So a few more. And finally, if it wasn't given to the monkey who famously took the monkey selfie. So most people in the room were right. So in 2017, Saudi Arabia granted citizenship to the robot Sophia. Also that same year, it was reported that a court in India ordered that the Ganges and its main tributary, the Yamuna, be given the status of living human entities. And what that meant effectively was that polluting or damaging those rivers would be equivalent to harming a person. So the odd one out here, as many of you recognise, and it did get a lot of media attention, was a failed attempt by an animal rights group to apply copyright protection for the monkey responsible for the famous monkey selfie. So the idea of giving legal status to a robot raises some really interesting questions, which it certainly did in the case of Sophia. And when we think specifically about how that would work with litigation, courts could find themselves having to determine whether a robot owes a duty of care to a patient. But who then determines what the standard of a reasonable robot is? And how would this actually work in practice? So it's an interesting but somewhat mind-boggling concept, and you might be relieved to know that whilst the issue of legal status has been discussed in the House of Lords report, it doesn't look like we are heading that way anytime soon. At the moment, it seems that harnessing AI in healthcare is not about replacing doctors, but it's about providing assistance. So what we're likely to see is a more sort of human-in-command system going forwards. So turning to mitigating some of these risks that we've been talking about, if we think about the example that Pete gave earlier, as well as some of the issues that arose in the Newcastle inquest case, one of the things that becomes really apparent is that with the development and the use of AI and robotics in healthcare, various individuals and organisations are now interconnected in a way that they weren't previously. And so when litigation does arise, we will have to determine how liability is allocated between those various individuals and organisations. And we've talked at length this morning about some of the areas of risk. And whilst there are clearly lessons to be learned from the Newcastle case, what we must remember, and this was touched upon earlier, is that robotics and AI in healthcare are still relatively new concepts. As we become more accustomed to the use of technology in diagnosis and treatment and surgery, we will hopefully avoid errors like those identified in the Newcastle case. Clinicians themselves will be better trained. They will intuitively pick up and use new bits of kit like many of us do with new smartphones or new laptops. And in time, that way of working will effectively become the new norm. So I'm now going to have a look at how clinicians and hospitals, manufacturers and developers can mitigate some of the risks that we've discussed and thereby allow for AI to be used to its full potential in a safe and effective way. So firstly, keeping an eye on standards, guidance and regulation, so both legal and ethical, is really critical, and that's not just UK-based regulation, but internationally. We've touched on some of the collaborative efforts that we're seeing, some of the sort of global discussions that are going on in terms of regulation, and so we're likely to see some convergence in terms of regulation going forwards. If you're a manufacturer, thinking about what regulatory oversight your company will be subject to and what submissions have been made or might need to be made to obtain the necessary regulatory approval for any products that are being developed. Suppliers need to ensure that before a customer uses a product, appropriate training is being provided, and that may also include providing clinical support services within a hospital setting. If you're a hospital or a clinician introducing new AI-based products or equipment, then think about what evidence is available to you regarding the safety of that product or its comparative benefit to more conventional forms of treatment. So, for example, have clinical trials been carried out? Were they independently verified? Are there research papers available to look at the advantages and potential disadvantages? Keeping an eye also on media reporting. So the inquest in the Newcastle case highlighted a number of omissions in terms of processes and procedures around the use of new technology. As unfortunate as it is, it's often only when adverse events happen and when things go wrong that gaps are picked up. Ensuring that you have robust contractual arrangements in place, so between suppliers, software developers, those providing training data, as well as end users. And understanding the development process, so understanding the ethics of the design of a product, validation of data, knowing that the data that has been input is appropriate for the solution that's trying to be achieved. And knowing your supply chain, so who is involved in creating the product, where are they based, who will use the product ultimately and how. So again, that's knowing it from right from the top, from the development of product all the way down to the end user. And finally, warnings and disclaimers, and this is particularly important for manufacturers and in the defence of any claims that might come up under the Consumer Protection Act. So with systems which use AI, it's really important to think about how your warnings and disclaimers can offer protection, and particularly in relation to human control over a system.
So we thought we'd leave you with a couple of thoughts to wrap up. If you want to look at these issues in more detail, I strongly recommend taking a look at the Academy of Medical Royal College's report that came out last year. It really goes into a lot of detail. They took a lot of soundings from lots of people involved, not just in healthcare, but in manufacturing and academia as well, breaking down lots of these issues. So take a look at that. One thing they really emphasized in that report is that there is a tension when it comes to AI in a healthcare setting. On the one hand, you have this tech mantra of moving fast, breaking things. If you're in Silicon Valley, you want to innovate, move quickly, and if you break things, it doesn't matter. But in a healthcare setting, the things you'll be breaking will be people, which is not a good outcome. So you have to balance that against the maxim of first doing no harm. But the good news is that whilst this tension exists here, as you've probably hopefully gathered over the last 40 minutes or so, the courts, regulators, governments understand that tension, and more guidance is coming out to try and help you all navigate your way through that in the future. And finally, we turn to the wise words of Vladimir Putin when discussing AI. A number of commentators on AI have likened the race to develop AI to a bit like a chapter in the Cold War, particularly the space race in the 1950s and 60s, where nations are competing with each other to provide the next technology and get one up on the other. There is a race going on, but I think from a healthcare perspective, hopefully what you've taken away from us today is that if you can innovate and work with the technicians and the computer people, but also keep an eye on the regulatory and legal developments, and you will be able to bring products to the market that will benefit everybody for excellent outcomes. Thank you.
Yes, please. Yeah, thank you, Peter and Emma. Always good to finish on a Vladimir Putin quote. So we have a 10-minute Q&A now. Again, we'll invite some questions from the audience. I see two hands. Where are the microphones?
Hi. Great talks. I'm Neil Andas from East Kent Hospital's an interventional radiologist. I just wanted to understand whether you thought it's realistic or just a pipe dream to get global consensus on guidelines when, as you just finished on this arms race, it's even possible, or is it more realistic that we're going to have a kind of Five Eyes-based standard, and then another standard for China and another standard for Russia? I just can't see people agreeing globally.
Yeah.
There's too much at stake.
I think if you were thinking from a Vladimir Putin perspective, I think you'd be correct. But I think we probably see more market forces at work which point in the other direction. So if you think from a manufacturer's point of view, you want to produce a product which is compliant with regulations around the world. So you'll probably find the most stringent regulations you can find, manufacture according to those standards, and be pretty confident that you can sell your product in multiple jurisdictions. And then behind the headlines, there are a number of bodies in the regulatory sector who are working together to try and bring regulations together, so more convergence than divergence. Looking away from AI, perhaps a better example might be biosimilars, where the EU led the way in regulating what was quite a new area of technology about 10 years ago. And then the biosimilar regulations introduced by the EU were then picked up by Australia and then have been largely replicated by the states. So I think taking it away from the headlines, I think market forces and regulators quietly talking to each other and using common sense probably means actually there are some good templates there for more convergence and divergence.
So that's just to say, so that's exactly what I'm saying. It was Europe, Australia, and the States. But there are other massive countries with their own huge populations. So do you think there'll be convergence between basically us and China? I mean, it's a 4 billion population or something in China, 2 billion.
Yeah, I mean, maybe our perspective is a bit blinkered by just virtue of the fact we work for people who are manufacturing and compliance in these jurisdictions I was talking about. So yeah, I can take your point that there could be almost two different systems. However, I suppose if you're having a Chinese perspective on it, you might be trying to attract business by putting in place a regulatory system so that manufacturers could bring their products to the market, say in China, gather clinical data to prove the safe performance of the product, but then that data would have to then be brought to regulators in the EU or the States, who would then look at it in turn, stress test it, and if it was good enough, then maybe the Chinese experience could give the manufacturer a boost in other places too.
So practice in China and bring it to Europe?
Possibly, yeah.
Thanks. Nizam Mahmood, I'm a surgeon at Guy's. The case that you described with the cardiac surgery, my reading of that really is that that was more of a governance issue, which could be applied to many new surgical techniques and a failure of governance rather than about the technology. But there are, it seems to me, qualitatively different issues with respect to the technology. So, for example, if you think of the Da Vinci robot, you can get screen freeze where the whole thing just stops, just like any computer, and your instruments are connected to something. You need to know what to do. You need to know what to do if you want the robot out of the way very quickly if the patient's bleeding. And do you not think that the manufacturers have a specific responsibility to ensure that people who are using the robot are trained in exactly those kind of issues? Because at the moment the training is relatively rudimentary. You have to undergo a basic training, but there isn't really a sense of you need to know all of those details about the technology. And as you said, most of us just pick up a bit of technology and give it a go, and if it works, it's fine.
Yeah, absolutely. I think that's an extremely good point, and that's why sort of some of the points you were saying at the end in terms of mitigating risk, it's not just when it gets to the point of the actual hospital and the clinicians in practice. It has to start right from the beginning. So manufacturers, developers themselves being actively involved in terms of knowing how that product is going to be used, who the end user is, and knowing that those end users are in a position to correctly use that product safely and effectively, which is why we touched on the idea of manufacturers possibly offering training within the clinical setting, so having sort of experts in place to oversee and to kind of advise on new procedures, and that's something that we have seen in a slightly different context. So in terms of implants, you might sometimes have someone from that sort of manufacturer or supplier who in the early days particularly has a sort of active role within the hospital setting to sort of oversee operations that are happening. It comes to sort of there being accountability at all levels. Effectively, it has to be a whole sort of chain process that everyone sort of is knowing what's happening at the next stage, and that it's not just about rushing to get new technology out there. That has to be that sort of continuity and to know that the knowledge is passed on. So I think it's going to change not only the manufacturers' roles in there being a training element to what they do, but also clinicians will be trained, like we've touched upon sort of earlier. Clinicians will be trained in a different way. They would also have more of an understanding around the products that they're using.
Hi. Peter and Emma, thanks. Fantastic talk. And more importantly, you ended up, Peter, in a positive note as well. I'm Raj Saha, just asking a couple of things on these issues. Obviously, the clinicians are going to be more apprehensive if they think that AI, especially in the clinical diagnosis making stage and implementation of that diagnosis, if they get wrong, so they are going to follow what the AI is saying, as you gave at the beginning, that your sat-nav, what it's saying and where you're going as well. And more importantly, if thing goes wrong, for example, if the clinician has done outside that what AI was suggesting, and in that situation, how the legal system going to support that clinical decision making of that clinician. So there are two strands of my questions. Thank you.
Yeah, I think the regulatory system of the government is catching up with this problem. So, for example, I don't know whether you've seen it, but about 18 months ago, the UK government published 10 principles for developing AI in the clinical environment. And interestingly, one of the 10 principles recognised that there could well be litigation and there could be questions about decisions made and how decisions are taken. And one of the 10 principles is that all parties involved, so as you saw on Emma's slide, you've got the manufacturer, you've got the software programmer, you've got the hospital, you've got the surgeon, all parties involved should right at the outset, at the beginning of a project, really work out where things could go wrong, and if things were to go wrong, who should be held accountable and who should bear that legal liability. And I suppose the advice we would give hospitals and doctors would be to really focus on that decision making about liability first, before you then agree to use any kind of new AI, so that you have got yourself protected. And then on the second part of your question, yeah, this is difficult to work out what should be the standard of care. So if you've got a doctor who is given, if you like, the sat-nav situation, and it clashes with their common sense and their experience, what should be done next? So I think from that point of view, communication amongst doctors, so there's a body of opinion about in any given setting, what's reasonable, what's not reasonable, and how much reliance should be placed upon AI, and how much cooperation there should be versus basing decisions upon your experience and your expertise. That, I think, is a debate which has yet to get to the courts, but I think we would probably recommend the clinical community having that debate so they're prepared for these difficult questions.
I believe we have one more question over here.
Thanks very much. Very interesting talk. It's Mustafa Mansour, Upper GI consultant from Manchester. Just a couple of comments here. I think as a medical profession and scientist, I think we need to recognize that there is a big difference between what we mean by artificial intelligence and actually gathering, analyzing data. I think we are still at the stage of we are trying to collaborate and gather data and analyze them through IT. And we haven't reached, because when we are talking about artificial intelligence, we're talking about analytical thinking, and we are not at that stage yet. And analytical thinking in the medical and the surgical profession is quite scary. And we're talking about autonomous thinking. So we need to be very careful, because what we were referring at the beginning of the session when we were talking about senior clinicians think differently from junior clinicians is because they have built experience through years in relation to how to analyze data and to how to deal with what they have been dealing with from the experience point of view. This now is being shortened by the IT or the technology for the junior clinicians to deal with that. The other comment from taking from Professor Mamoun's comments is that we are lacking at the moment the training in technology as surgeons, and that's a big issue. We are trained to do the surgery, but doing surgery through instruments, especially robots, is not the technicality only of surgery. It's also how to deal with the technological glitches that might affect your surgery, and then litigations will start coming.
Yeah, I think that, I mean, absolutely sort of really key comments there, and there's certainly concerns I think that we have heard from sort of other clinicians and hospitals as well, that what I can sort of imagine seeing effectively is the way that doctors will be trained going forwards will need to change. It will need to sort of include other elements to it, and it will become much more of a sort of technology-based training, a sort of whole different skill set. And I know that, this is something that sort of the health sector has picked up on in terms of his vision for, the NHS to be a world leader in terms of technology in healthcare. There are significant gaps. This is what we're hearing from industry at the moment in terms of that level of knowledge, that skill set. So I think you're right. This is something that desperately needs more attention, and it needs probably more funding and focus as well to ensure that it's all very well to have the technology advancing and it being the aim to implement it within the health sector. But if you don't have the people who are sufficiently trained and adequately trained to use it, then its role is going to be limited and potentially extremely dangerous.
Yeah, and thoughts on that is we're often told that the jobs our children will be doing in 20 years, half of those jobs have not yet been invented. And you do wonder if you might see the rise of a new profession, which is the clinical computer scientist, who would fulfill that role. Although that could mean that the cost savings heralded by AI might be chewed up and having more human beings having to be there to make those ultimate decisions.
I think there might be some challenges to the question raised here later on in the afternoon.